So welcome to episode 3 of the Bulletin. We're going to be answering some questions we received from some of our HR audience members. If you have any questions, you can send an email to our producer, and the email is in the description in the podcast. So Charlie, let's move forward with some of the questions. First question, can immigration change their minds midstream on which chart they'll be using for USCIS adjustment of status applications? So again, just as a refresher, we have the chart A, which is the final action date, and then we have chart B, which is the date for filing.
Historically, that has not happened. USCIS will make a determination as to whether they will use the upcoming month's application filing dates, allow them to be used or not. For example, now the March Visa Bulletin has recently been published. They have indicated on the USCIS website that the application filing dates listed in the March Visa Bulletin will no longer be allowed for early application filings.
Yeah, there was some confusion in our office too, where people thought you could still use chart B for employment-based adjustments, but you can't use it for March any longer.
No, you can continue to use it for the month of February, but come March 1st, only chart A, the final action dates, will be used by USCIS for filing for adjustment of status.
So you have 2 weeks left to get your cases filed under the Chart B dates for filing. Another question was about the high volume EB2 countries like Brazil and South Korea. Do you see any projections on those being removed or moved away from rest of world and going into their own category?
No, I see no reason to be concerned with those countries being added. Although they do use a large amount of employment numbers, their family-sponsored number use is extremely low compared to the annual limit, and those unused family numbers fall down for use in the employment categories.
So have you ever seen Brazil and South Korea move from rest of the world?
Not that I can remember that ever happening.
Okay, and we always get this question about the EB3 Philippines. Do you project that to be moved from rest of world as well?
I think that there is a chance during this late summer months that the Philippines employment third preference may fall slightly behind the rest of world final action date.
Okay, but not until the summer months. I get this question a lot from my nurse healthcare clients. So it's going to stay the same. And if it even is moved from rest of world, it will just be a little bit slower and it'll be in the summer months. Right?
Yeah, I would expect state, again, when I was chief, I would always try to delay any retrogressions until August or September, knowing that it is very disruptive to the applicants and attorneys handling their cases. And therefore, I wanted to have as little time disrupting before the new fiscal year's annual limits apply, and there would be numbers once again. So again, with the Philippines' third preference, I think it may fall slightly behind the rest of world final action date, but that would not happen until August or September. And I think that it would still be within 1 to 2 months of the worldwide date.
Okay. And then the good news is it usually moves back into rest of world in October when the fiscal year opens.
Typically, but we will have to see how far it may fall behind the rest of world date. And another thing that will impact Philippines is potentially the lower worldwide annual limit for fiscal 2025. Okay. But again, I think it is too early to worry at this point. We may know more going into the early part of the summer or late summer.
Okay. And then another question, what drives USCIS to accept or reject the Department of State filing dates or the dates for filing or Chart B?
USCIS will only allow the Chart B dates to be used if they feel there are numbers available for any new applicant using those dates to file. And for the month of March, USCIS has determined that there has already been enough numbers used in the employment categories, plus what will be used in February, and the amount of applicants who have already filed for adjustment of status under the Chart B dates to fully utilize all the remaining numbers available for use in the March through September time period. So therefore, effective March 1st, they will only allow the Chart A final action dates to be used for adjustment of status filing.
Okay. And then would you explore possible rationale behind the 7% country cap? What is the biggest concern in removing it altogether?
The reason Congress imposed a 7% limit is to avoid a handful of countries from potentially monopolizing the vast majority of numbers under either this family-sponsored or employment-based limits. If there were no 7% per country limit applied in the family-sponsored categories, Mexico and Philippines could use virtually all of the available numbers. And in the employment categories, India, China, Philippines, and possibly Korea could use virtually all of the numbers available in the employment preference categories under the annual limit.
Okay, so the 7% country cap is not going to go away.
It has been proposed. Every proposal has failed to this point, because if the 7% country limit were to go away, for example, in the employment third preference category, Indian applicants would use virtually all of the numbers. There would be minimal amount of numbers remaining available for use by any other applicant from any other country.
And again, this 7% country cap came into play back in what year?
There has been some form of a per country limit since at least the Immigration Act of 1990. I would have to refer. I can't remember if pre-M Act 90 what the per country limit was, but
there was always a per country limit, not it being 7% or higher or lower. There has always been a per country limit.
Yeah, in the very early days, there were actually country quotas that were listed, and they varied. The amounts varied among each individual country.
Yeah, we're going to have another podcast where we go through the history of the Visa Bulletin. So you can tune in there to hear about the history of the Visa Bulletin and these country caps. That's all I have for today. Charlie, any closing words?
No. Just in the monthly Visa Bulletin, always pay attention to any notes that may be listed after the Chart A and Chart B dates. The State Department, if they see anything that potentially would be coming down the pike, say visa retrogression, limited number use, or more rapid number use or movement of the dates, they will often list that in a note in the Visa Bulletin.
Okay. And we'll also go through the notes when we do our the Bulletin podcast as well. If you have any questions, again, you can send an email to our producer. It's in the description, and we look forward to chatting again in the future and answering your questions.